Okay, good evening, everyone. I'd like to call to order the November meeting of the County Plan Commission. Jackie, to get us started, would you please call the roll?
Yes. David Bush.
Here.
Margaret Clemens. Trona and Wright Randolph. Scott Ferris.
Here.
Rudy Fields.
Here.
David Henry.
Here.
Jeff Morris.
Here.
Julie Thomas. Here. Joe Vandeventer.
Here.
Okay, so we have 7 members in person and a quorum.
Okay. To get us started tonight, Mr. Vandeventer, I'd like to administer the oath to you. So if you could raise your right hand and repeat after me. I, Joe Vandeventer, do solemnly swear
I, Joe Van Deventer, do solemnly swear
that I will support the constitutions of the United States of America
that I will support the constitutions of the United States of America
and the state of Indiana,
and the state of Indiana,
and that I will faithfully and impartially perform my duties
that I will faithfully and impartially perform my duties
as a Monroe County Plan Commission member,
as a member of County Planning Commission member,
according to the law and to the best of my skill and ability.
according to the law and the best of my skill and ability.
Thank you, and welcome to the Plan Commission.
Thank
Happy
you.
to have you here with us.
Thank you. I'm glad to be here.
Okay, Jackie, to continue, could you introduce the evidence for tonight?
Yes, I'd like to introduce the following items into the evidence. The Monroe County Development Ordinance as adopted and amended. The Monroe County Zoning Ordinance and Subdivision Control Ordinance as adopted and amended. The Monroe County Comprehensive Plan as adopted and amended. The Monroe County Plan Commission Rules of Procedure as adopted and amended. And the cases that were legally advertised and scheduled for a hearing on tonight's agenda.
Okay, do we have a motion to approve the evidence?
Second.
Okay, it's been moved and seconded to approve the introduction of evidence. A vote yes is a vote to approve. Scott Ferris,
Yes.
Rudy Fields,
Yes.
David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas. Yes. Joe Vandeventer,
Yes.
David Bush.
Yes.
Motion is approved 7-0.
Okay, do we have a motion to approve tonight's agenda?
So moved.
Second. Been moved and seconded to approve tonight's agenda. And just a note, we do not have any proposed changes to tonight's agenda, so as presented is correct. A vote yes is a vote to approve tonight's agenda. Rudy Fields,
Yes.
David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas. Yes. Joe Vandeventer,
Yes.
David Bush,
Yes.
Scott Ferris.
Yes.
Motion is approved 7-0.
Okay, we have no minutes to approve tonight, so before we jump into administrative business, I want to mention that items 1 and 2 under unfinished business and item number 1 under new business have been continued by staff as noted in the agenda. So if there's anyone here to speak on those will not be heard tonight. So we can move now to administrative business. The first item is the CDO amendment prioritization list. Jackie?
Yes, as we're closing out, coming close to the year, we have made some gradual progress on the prioritization. There's 2 items that will be updated as part of this prioritization. One was passed by the Plan Commission or given a favorable recommendation by the Plan Commission and will be going to the commissioners soon. And the other is going to be heard I believe at the Ordinance Review Committee and the Plan Commission Administrative Meeting in December. So that is the update.
Thank you for that update. Item number 2 on the agenda is the 2025 meeting calendar update.
Right, so this is 2025 meeting schedule, and we found out last week that we were not going to have access to Suite 100B, which is where we have held the Historic Preservation Board of Review and also the Plan Commission Administrative Meeting. We are going to be holding that in the Showers Room 224, and that's basically us changing the calendar here. So it'll be in our office for the remainder of the year. I think we need to vote on adopting it.
Okay.
I'm going to present the 2026 at the same time.
I could do that one
since
as well.
It's the same change.
2026, same thing. We've amended the room location to Showers 224 for HP board and PC admin. And then we also, because we have the holiday schedule from the commissioners, we were able to choose a date for the voting days. So we included those, but we still do not have the county council meeting dates for the budget hearings. So we'll be adding more dates eventually.
Okay, thank you, Tammy. Do we have a motion to approve the 2025 meeting calendar update and the 2026 meeting calendar update?
So moved.
Second.
Okay, it's been moved and seconded to approve both the 2025 and 2026 meeting calendars as presented in the packet. A vote yes is a vote to approve. David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas,
Yes.
Joe Vandeventer,
Yes.
David Bush,
Yes.
Scott Ferris,
Yes.
Rudy Fields.
Yes.
Motion passes 7-0.
Okay, we'll move on to unfinished business. We will move to item number 3, SIA-22-18. This is the Holland 3-lot minor subdivision, request for inflation-adjusted performance guarantee amount.
Right. So one thing I do want to note is that there is a representative here tonight. I believe Lana Allen is available. However, the engineer that's associated with this and the attorney that's associated with this petition will not be available this evening, but they wanted to keep it on the agenda and moving forward. So this is the Holland 3-lot minor subdivision recorded back in July of 2019. There's still one remaining lot open and vacant, which is the Smithville telephone lot. There are public improvements associated with this subdivision that need to be completed. One is the sidewalk that runs along South Walnut Street Pike, and then also some street trees I think were needing to be completed. And this is, of course, integrated with the Holland Fields Phase 1 subdivision. So we're working with both those developers to try to get them to complete these public improvements and get them adopted into the Monroe County inventory. So again, just to review, we've got a driveway for Lot 1, which does not meet ADA compliance, and also same with the driveway for Lot 2. So there's some interesting utilities issues that are possibly in conflict, which will make this a costly repair to drop this sidewalk and to correct these driveways. But without that, we cannot accept those into the county inventory. So I have a bit of a summary. So the original estimate from the 2019 was $5,115, and that was to cover the cost of installing sidewalks and street trees, and it was held in the form of a cashier's check by the county. Earlier this year, the Plan Commission agreed to have the developer aim for a performance period of June 30th, 2026, so it will be completed within the year, hopefully. We also are having the Holland 3-lot primary plat amendment 1 was required to be filed, and that is going to be immediately following this. In fact, I'd almost prefer that you hold the vote for this petition until after you've heard the new business of the subdivision primary plat amendment. So the request on the primary plat is basically to have them change the road width, which was originally approved at 32 feet, and let it remain at 26 feet, which is what they built it as. And then as a part of that, we've been reviewing some of the driveway permits for Lot 1, Lot 2. We still need Lot 3 to be filed, I think, at this point. So the big issue is that East Holland Drive was originally constructed at a higher elevation, and the Highway Department required that the road be removed and then reconstructed at an acceptable lower elevation for safety concerns. The sidewalks and the driveways were never lowered and regraded to match the grade of the road, which is what the problem is here. The stated reason by the contractor was that there was that potential conflict and the cost for relocating the Smithville fiber utility. I did get an email, which did not make it into the packet. We got it I think the day after, from a representative of Smithville, because Blackwell Contractors LLC representative met with Smithville Fiber on site. And the resulting email is that the only way to confirm for sure that Smithville's duct and fiber cable are not in conflict is for the constructor to spot the duct fiber cable. Smithville is not in conflict based off of the locator depths if you are just lowering 8 inches. But as the contractor, you will need to spot the duct fiber to visibly determine if Smithville is in conflict. The locators, I guess, can have interference, such as rebar in the sidewalks that can cause depths to be off. Therefore, if you spot cable and it is in conflict, Smithville will have to create an estimate, that estimate to be paid, and then the relocation completed before you are able to proceed lowering the sidewalk. Smithville would like to have someone on location while spotting the fiber cable and completing this construction. In the event there are issues, please contact me. So that's one of the big conundrums we have with this location here and getting the subdivision completed. So one of the big things that came out of all of our meetings that we've had recently and planning and everyone's hard work is that we actually have an estimate agreed to by both sides for the remaining public improvements that need to occur out here. The total for the sidewalks, the street trees, they are also going to do some improvements with roll curb and gutter, and a little bit of tapering out here. So we did have on file just over $5,000. We are going to be requesting that they have $20,777.88 on file, and that we will not be charging them interest because they have agreed that they will have this complete by June 30th of 2026 from our prior agreement. So for this specific petition, I'll go ahead and give the staff recommendation for SIA 22-18, even though I think you guys should wait and hear the primary plat amendment first. But staff recommends approval of the estimate amount of $20,777.88 with the following conditions. The performance bond document shall be signed and recorded by December 11th, 2025, and a new financial guarantee shall be submitted in the form of either a letter of credit or a cashier's check by December 11th, 2025 that satisfies the amount of $20,777.88. So I guess, do they need to have like to agree to not vote on this at the moment and then we move on to new business? Or
The public will be able to speak on this, so if you want to hear them both together, you will still have to call for public comment for each one individually.
Okay, I can go ahead and call for hearing from the petitioner, public comment, and then I can make a motion to table the vote until after item number 2 under new business.
Okay.
Okay, before we continue, do any members of the Plan Commission have questions for staff? Okay, seeing none, we can turn now to the petitioner's representative. If you're here in the room, you're welcome to come to the podium. You would have 15 minutes to speak to this. If you're online, please raise your virtual hand.
I see Lana is there, but she may not want to speak.
Okay.
So
Then we will move on to public comment. If there's anyone here in the room who wishes to speak for or against this petition, please come to the podium. Okay, seeing no one, if there's anyone online who wishes to speak for or against this, please raise your virtual hand. Okay, seeing none, I will make a motion that we table the vote on this and the discussion on this amongst Plan Commission members until after item number 2 under new business.
Second.
Okay, it's been moved and seconded just to hear the new business item SMN-25-5 before hearing a vote on number 3 under unfinished business SIA-22-18, and the vote will be had together. A vote yes is a vote to combine those presentations by staff. Julie Thomas?
yes.
Joe Vandeventer?
Yes.
David Bush?
Yes.
Scott Ferris?
Yes.
Rudy Fields?
Yes.
David Henry?
Yes.
Jeff Morris?
Yes.
Motion is approved, 7-0.
Okay, let's move on then to new business, and we'll move to item number 2, which is SMN-25-5. This is the Holland 3-lot minor subdivision primary plat amendment 1. This is the preliminary hearing, and a waiver of final hearing has been requested.
All right, so this one, we have 3 owners of the lots. They're kind of a part of this petition, and they've all been noticed. We have the recorded final plat that was from 2019. And this is a primary plat amendment, but the changes that are happening at the primary plat level are not going to be requiring that the final plat or the secondary plat be amended. So this will still remain as is. It has the proper amount of right-of-way dedicated. And yeah, we won't need to be changing this. On November of 2017, a primary plat was approved by the Plat Committee for the Holland 3-lot minor subdivision. Let's see, and it was to subdivide a 1-acre lot into 3 lots totaling 0.97 acres once right-of-way was dedicated. And the petitioner here in this case is requesting a primary plat amendment to this subdivision plat so that they would not have to require a road width change. So the road that was approved, this is part of the plat, was for a 32-foot width, which allowed for some tapering, a little bit more of a safety aspect from transportation perspective. This road was built and then it was required to be removed and rebuilt. And in that whole shuffle of process, it was built back to the 26-foot width, which was under the Holland Fields subdivision requirement. So this plat amendment is basically to allow this to remain at a 26-foot width, which is what it is currently built to at this point in time. This is also allowing us, and this is just some of the other showing the 26-foot width in the field, and then an email back from 2017 where they did, the highway department did want to have this flared out from 26 to 32. It didn't happen. It was an oversight during the rebuild, I think. So we have this new primary plat, and it is actually allowing us to do some improvements at the intersection of South Walnut Street Pike and East Holland Drive. So there's going to be a bit of curb and gutter put in here, as well as the design of the sidewalk that was required. And it's actually going to kind of take a little jog to the west, so it will avoid a tree. That does still allow it to touch the property line, which was a comment that the highway engineer had on this one. And then I think we are also having the driveway permits reviewed for Lot 1, Lot 2. We still need to have a driveway permit submitted for Lot 3 just to prove that we have access out here because of the fiber, because of the slopes, and the fact that the sidewalks are going to be dropped out here by the other developer of Holland Fields. So we just want to prove that we have that Smithville will have access to their lot. So those are some of the changes that we're seeing as a part of the primary plat amendment. We're correcting some drainage that occurred when they rebuilt it. And let's see. And then we did have finally some driveway permits submitted on November 13th, and that had been a condition of approval by the Plat Committee. So the Plat Committee did meet on October 16th? Yeah. And forwarded a positive recommendation with a vote of 5-0. There were 4 conditions of approval, but 2 of those have been met already and removed from the recommendation. We have the highway department's comment actually has been satisfied, and the drainage board, they heard this at their October 14th meeting, and they voted unanimously to approve this petition. But they noted that the individual property owners will still need to apply for variances for their fences that have been installed within platted drainage easements. And so we have also made that a condition of approval. I believe that's the second condition. And so with that, case number SMN 25-5, the Holland 3-lot minor subdivision primary plat amendment 1, we're recommending a positive recommendation to the Plan Commission based on the findings that the proposed primary plat meets the subdivision control ordinance, I would say the county development ordinance, subject to the highway engineer and stormwater program manager reports, with the following conditions: that 1, the developer and their engineer show corrective measures to the driveways for Lot 1, Lot 2, and Lot 3 so that the developer of Holland Fields Phase 1 can complete the remaining East Holland Drive sidewalk corrections in order to request right-of-way acceptance. And the developer must apply for right-of-way activity permits for all 3 driveways to be corrected and complete the work on or before May 1st, 2026. And they do have, and I say this is partially completed because they've got applications for Lot 1 and Lot 2 submitted, though they have not been fully reviewed. They still need to do one for Lot 3. And then the Drainage Board requested that the individual property owners for Lot 1, Lot 2 apply for variances for the fences built within the platted drainage easements. And I can take any questions on either of those petitions. I also have the SIA just right below it as well, so we can look at that recommendation.
Do any members of the Plan Commission have questions for staff? Okay, if there are none, we can turn to the petitioner or petitioner's representative. If you're online, please raise your virtual hand if you wish to speak. Tammy, do we know if the petitioner or petitioner's representative wishes to speak?
Lana Allen is on the line listening. I don't think she wanted to speak necessarily.
Okay.
But
Okay. Thank you.
she might be able to answer a question possibly. But again, their engineer and their attorney are not here this evening to also
Okay, thank you. We can turn now then to public comment. If there's anyone here in the room who wishes to speak for or against this, you're welcome to come to the podium. Or if you're online and wish to speak for or against this, you can raise your virtual hand. Okay, seeing no one, we can come back to the Plan Commission for discussion. Or if there is no discussion, we could turn to a motion.
Okay. So if we're going to make a motion, can we combine these two, or do we have to do them separately?
I almost think it's separately because they have different case numbers and different conditions associated with them.
So
And I can flip between the 2 slides if that helps.
let's go with, that's what I was going to say. So for case number SM Sierra Mike November 25-5, which is the Holland 3 Lot Minor Subdivision Preliminary Plat Amendment 1, I recommend that we approve based upon the information provided by staff. This request. I'm not going to restate the 2 paragraphs here, but as stated by staff. The motion is to approve.
Hey, do we have a second? Second. One quick clarification, Jackie. Is this an approval or is this a recommendation to the commissioners?
It's approved.
This is an approval.
Okay.
That's us.
And is this a final, it says in the box that this is a request to waive the final hearing? So do we need that added in?
And so I would add also, do we waive the final hearing
No,
as well?
I'll second that. Sorry, I
Okay.
missed that.
Sorry, I had marked down.
I missed it.
It's been moved and seconded to approve SMN-25-5, the Holland 3-lot minor subdivision primary plat amendment 1 with a waiver of final hearing requested. And this is including the conditions in the staff report, which are as follows. That's a approval to the Plan Commission based on the findings that the proposed plat meets the subdivision and county development ordinance, subject to highway engineer and stormwater program manager reports with the following conditions. 1, the developer and their engineer show corrective measures to the driveways for Lot 1, Lot 2, and Lot 3 so that the developer of Holland Fields Phase 1 can complete the remaining East Holland Drive sidewalk corrections in order to request right-of-way acceptance. The developer must apply for right-of-way activity permits for 3 driveways to be corrected and complete the work on or before May 1st, 2026. And 2, the Drainage Board requested that the individual property owners for lots 1 and 2 apply for variances for the fences built within the platted drainage easements. A vote yes is a vote to approve with a waiver and with the conditions as stated. Joe Vandeventer,
Yes.
David Bush,
Yes.
Scott Ferris,
Yes.
Rudy Fields,
Yes.
David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas.
Yes.
Motion is approved 7-0.
Okay, so we will move back to item number 3 under unfinished business, and I will call for a motion on that item.
All right. With respect to Sierra India Alpha 2218, which is a request for an inflation-adjusted performance guarantee amount, I recommend we approve that estimate of $20,777.88 with those following conditions as stated by staff and also indicated on the board.
Waiver?
Hmm?
Is there a waiver?
There is no waiver.
There's no waiver.
Okay, do we have a
I
second?
looked.
Oh, that's right, because it's the bond. Thank you.
Okay, we have a second?
We do have a second.
Commissioner
Great,
Thomas, yeah.
okay. It's been moved and seconded to approve SIA-22-18, which is the Holland 3-lot minor subdivision inflation adjustment performance guarantee amount. That is in the amount of $20,777.88 with the following two conditions. 1, a performance bond document shall be signed and recorded by December 11th, 2025. And 2, a new financial guarantee shall be submitted in the form of either a letter of credit or cashier's check by December 11th, 2025 that satisfies the total amount of $20,777.88. A vote yes is a vote to approve the motion with the conditions as stated. David Bush,
Yes.
Scott Ferris, Rudy Fields,
Yes.
David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas,
Yes.
Joe Vandeventer.
Yes.
Motion is approved 7-0.
Okay, moving on to item number 3 under new business, we have REZ-25-6. This is the Monroe County Nature Preserve rezone from CVR to IP. This is a preliminary hearing and a waiver of final hearing has been requested. So, Mr. Brown, I will turn it over to you.
Thank you. So this is the request is the rezone of 409.48 acres more or less from conservation residential 2.5 to institutional public. Purpose is that the Monroe County Commissioners and the Parks and Recreation Department are interested in establishing the Monroe County Nature Preserve at this location. This is a preliminary hearing with a final hearing scheduled for December 18th, but a waiver of final hearing has been requested and may be approved at this meeting. So the petitioner is the Monroe County Board of Commissioners, and they are proposing the rezone. A comparison of the list of permitted and conditional uses is located in Exhibit 3 of the packets for compare and contrast between the current zoning and the proposed zoning. So a bit of background, in November of 2023, Nancy Huntington passed away, and upon her passing, she deeded 409 acres to Monroe County for recreational purposes only. To determine the language of the trust, including the meaning of the term recreational purposes, a hearing order under clause number 53C01-242-TR-000243 was enacted, and the definitions are included below as follows. Would the commission like me to read through them?
I don't believe you need to. Thank you.
All right. So the county is limited on using the nature preserve only for the uses that fall under the definition of recreational purposes as described in the order. Further, the Huntington property changed names to the Monroe County Nature Preserve under Resolution 2025-32. This was approved by the Board of Commissioners during their meeting on July 24th, 2025. There are existing structures on the property, including some that were previously used for residential purposes. Discussion about the leased buildings and the property were discussed by Commissioner Jody Maderia during the August 14th, 2025 Board of Commissioners meeting. Also, these leases did not meet the judge's order on the definition of what the property could be utilized for by the county. At this point in time, Monroe County has very limited plans to develop the nature preserve. It could include, but is not limited to, hiking trails, natural areas, and possibly a dog park. We recommend that questions about the nature preserve be directed to the Parks and Recreation Department by the public. And here is the location map and comprehensive plan map, as well as the zoning map. A lot of the property is in the environmental constraints overlay area 2, which is in the Lake Monroe watershed. And the image on the left is a view of the field from State Road 46. And the image on the right is from an incomplete driveway that was supposed to connect to Night Ridge. It is my understanding that Parks and Rec has considered developing that and making it a full-on driveway entrance. And these two images show one of the currently existing residences on the property. The image on the left is of a bulletin board, presumably, or a gate from the driveway entrance, and the image on the right is of the house itself. And here is an aerial image of a residence as well as several accessory structures which connects to State Road 46. 446, sorry. And here are the use tables for the Conservation Residential 2.5 zoning district and the Institutional and Public zoning district. We have had comments from other departments. From the Highway Department, Ben Harris has said no right-of-way activity permit application has been submitted for this petition. A proposed driveway entrance was determined back on June 13th, 2025, and will be approved off of South Night Ridge Road. Please submit a right-of-way activity permit for the new proposed driveway entrance prior to site plan review. I do not have any comments or issues at this time. Meanwhile, from Stormwater Departments, Erica Penna says no comments or concerns regarding this rezone. Stormwater grading permit and state permit applicability will be reviewed at the time of development. For letters of support and letters of remonstrance, staff has received one letter of support after the packet was published, as shown in the image on the right, and no letters of remonstrance were received. I will leave this up for a moment so that the commission could read it. And so staff recommends a positive recommendation for the rezone of the Monroe County Nature Preserve from Conservation Residential 2.5 to Institutional and Public based on the findings of fact and the comprehensive plan analysis that were approved in the packet. And I will take any questions.
I would, if I could.
Commissioner Thomas?
I don't have any questions, obviously, but I did want to note, for those who have questions on the terms of the trust, our attorney, Justin Roddy, is actively online on Teams, and I thought we had somebody here from Monroe County Parks and Rec, but I do not see anyone. Are they both here? Oh, there we are. Thank you. There you've been online, and now here you are in person. So we have these two folks here who can shed some light for Plan Commission members who have questions about any of the aspects of this project.
Thank you, Commissioner Thomas. Do any members of the Plan Commission have additional questions before we turn to the petitioner's representatives? Mr. Roddy, and if you could come, Ms. Whitmer, thank you, sorry. If you could sign in and state your name.
Yes, Justin Roddy, Monroe County Legal Department. And I think we received a pretty good background information about the trust as well as trust interpretation. So I'm here to answer any questions that the commission may have.
Yeah, Councilmember Henry.
Thanks. Yeah, thanks, Justin. So is the full copy of the trust available somewhere that we could review, like the entire document, or because we have a snippet here in the packet, but is the full?
I have a copy in my
Great.
office.
I'll come take a peek. I'd like to read the whole thing. So my only question is really, it seems like the language of the trust for recreational use is more expansive than the IP designation in the CDO, because I think as I see the word fitness center, which seems to encompass, I think, what everything the trust is identifying as possible use. Is that a fair way to think about it? I mean, because I think under the CDO, I think I'm zeroing in on fitness center, which can include sports activities. But then we got the language of the. It's under conditional use. No, it's actually. It's not the conditional use one. It's the other one up top. There's an item for, I think, fitness center as
Parks and playground is also.
Playgrounds, okay.
Yes.
And that would encompass, in terms of the trust, is identifying things like sports fields, aerial sports, and the like. Is that okay? Because it seems like there's more specificity in the trust than what we have in the CDO in terms of what can go on in there as allowable use. I'm just curious how that plays out.
The trust interpretation, as was interpreted by the court in the hearing order, was written in very broad strokes to essentially encompass anything that we might potentially do there. It includes things that we, frankly, have no intention of doing in even the relatively long term. It was drawn from cases that both myself as well as the Trustees Council found, so it is a pretty expansive definition. Obviously, we'd be limited by anything in the IP designation should the commission choose.
I think it's more of a comment, but does both staff and county legal then feel like there's enough flexibility of options for use in the two, both in the CDO and then what we have in the definition from the court?
When I examined the IP designation, and Ms. Jellin and I went over that maybe last week, I did not see any issues with the limitations there versus what was in the trust, especially for our short-term plans. By short-term, I mean 2 or 3 decades.
That's good. That's it. Thank you.
I think you can imagine it like a Venn diagram, and there's the institutional public, there's the trust. Where they overlap is what we're planning for now, which is not much. So it's really meant to be a nature preserve.
Okay, are there any additional questions for Mr. Roddy from members of the Plan Commission? Seeing none, Ms. Whitmer, did you want to speak also, or were you here just to answer questions?
Hello, Kelly Whitmer, Director of Monroe County Parks and Recreation. And we've learned, Justin, when we write stuff, we want to write it for 100 years, 500 years. I don't know what in 500 years this community may want there, but I do know what we want today is a nature preserve with many grass trails, maybe a dog park, maybe a shelter someday. But I don't know what 500 years might hold. So we don't want to limit those people in the future. But for now, and probably for very many decades, lots of trees, lots of grasses, lots of wildflowers. Does anyone have any questions?
Not seeing any questions. Thank you. Okay, we can turn now to public comment. If there's anybody here in the room who wishes to speak in favor of this petition, you're welcome to come to the podium. If there's anyone online who wishes to speak in favor of this petition, please come, or please raise your virtual hand. Okay, not seeing anyone. If there's anyone here in the room who's against this petition, please come to the podium. Or if you're online and opposed to this petition, please raise your virtual hand. Okay, seeing no one, we can come back to the Plan Commission for further discussion and/or a motion.
I just want to say thank you again to both Ms. Whitmer and Mr. Roddy for being here today. I appreciate it because we had questions come up at the admin meeting and just in case. So thank you both for being here. Appreciate you.
Thank you, Commissioner Thomas. Any other comments? If not, believe it's time for a motion.
With respect to case number Romeo Echo Zulu 25-6, with the request of rezone request to change the zoning from conservation residential 2.5 to institutional public, in addition to a waiver for a final hearing. The motion is to forward a positive recommendation to the county commissioners for approval.
Do we have a second?
Second.
Okay, it's been moved and seconded to send a positive recommendation for REZ-25-6, which is the Monroe County Nature Preserve, rezone from CVR to IP with a waiver of final hearing. A vote yes is a vote to send a favorable recommendation and waive the final hearing. Scott Ferris,
Yes.
Rudy Fields,
Yes.
David Henry,
Yes.
Jeff Morris,
Yes.
Julie Thomas,
Yes.
Joe Vandeventer,
Yes.
David Bush.
Yes.
Motion is carried 7-0.
Okay, thank you, and I will echo Commissioner Thomas's thank you to the Parks Department and to legal for making this happen. I'm excited to see it come to fruition for the county. So moving on to item number 4, SPP-25-2. This is the Bella Vista Section 3 Subdivision Primary Plat Amendment 2, Sidewalk and Street Tree Waiver Request. This is the preliminary hearing with a waiver of final hearing requested. So Ms. Nestor Jelen, I will turn it over to you.
All right, thank you very much. So I'm just going to go over a quick summary of the Bella Vista report. Hopefully you had a chance to review it. There's several exhibits that I'll touch base on, but it's fully in the report as well. So the request here tonight is to amend the Bella Vista Section 3 only to remove the requirement for street trees and sidewalks. This contains 50 lots. The developer is wanting to waive the remaining sidewalk, subdivision improvements, and street tree improvements. And if it's waived, they can receive their funds back that the county has been holding since their approval in 2006. So that would amount to $50,770.50. So when Bella Vista Section 3 was originally recorded in 2006, the developer was made aware of the street tree and sidewalk requirements on one side of the road for sidewalks, both sides for street trees throughout the subdivision. And the sidewalks have never been installed. The street trees, there are some street trees maybe by lot owners' own planting or possibly the developer for some of the more vacant lots. On account this morning. There were 149 trees. So there's currently no sidewalks in phases 1, 2, or 3 of Bella Vista, and this was brought up as a discussion point by some of the neighbors when we had the prior subdivision improvement agreement discussion with the Plan Commission about how to move forward with the limited funds of $50,770, which would not cover today's amount required to put in the street trees and the sidewalk. So Section 1 was approved in 1989, and that was before our ordinance contained requirements for sidewalk or street tree requirements. So they were approved without those improvements as a requirement. Section 2 received waivers from the sidewalk and street tree requirements. However, they did plat a 5-foot easement along the lots for a future sidewalk. And Section 3 had only requested a sidewalk waiver at the time. They agreed to the street trees as they did not request a waiver, but they were denied originally and came back, and finally the subdivision was approved with sidewalk only on one side of the road. So the developers annually renewed the letter of credit since its recording in 2006. And when we contacted the developer in October of 2024, as the county development ordinance was underway, we had asked about their timeline for completion of these remaining improvements and had a case file for it under SIA 2228. Eventually, the developer's request was decided for the SIA, the Subdivision Improvement Agreement, at the September 2nd, 2025 Plan Commission meeting. And essentially, the vote was to request that the Planning Department draw the financial guarantee and work with residents to file primary plat amendment for the 2 waivers for street trees and sidewalks. The developer then did step up and apply for this plat amendment, so they are the applicant in this case, not the residents, which is what we originally thought might happen. So the Planning Department has cashed the letter of credit per the requirement by the Plan Commission and because it expired on October 27th of this year. But again, if the waivers are approved tonight, the developer would be able to be refunded this amount. So as of today, under the subdivision, the money that we have would only be able to be used for sidewalks, street trees, thermoplastic stop bars, which are no longer a requirement under the highway code, and stop signs, which have been installed for some time. And we estimate that each of these improvements are going to total $710,332. Since we did the street tree count this morning, we were able to come up with the estimate of that by itself, which is $81,950 of just the missing street trees. I will say, if you have not been out to Bella Vista, they have several conservation areas between lots and the backs of lots. So even where there's not street trees, I was able to easily point out in proximity well-established trees in the near area. So the big point on this one is that the county did accept Bella Vista Section 3 into the inventory on December 5th, 2008 it was a prior highway director and prior leadership. So typically today, we would not allow for acceptance of roads into the inventory without meeting the requirements approved by the Plan Commission. That's how we get people to finalize and finish those improvements. So the omission of sidewalks and street trees in this case should have prevented the acceptance, but it did not. So that is why partially the letter of credit was annually renewed and no one had too much issue because the county was still plowing the roads and maintaining it. And that usually is why people call us. This is an aerial of Section 3, just the outline of it in yellow, and then Sections 2 and 1 are to the north of that area. And then in yellow, you'll see the location of where the one side of sidewalks were supposed to be located. There are no sidewalks at all throughout. And then we also have the location of street trees. The non-highlighted trees are the ones that are missing. So you'll see there's several segments missing. But as I mentioned before on a site visit this morning, there are several trees throughout the subdivision interior to the lots that are there. And then I have some photos from earlier this year where we're just looking at kind of the picture of what the streets look like, what Bella Vista looks like. I'm standing on East Tierney, and this would be a situation where sidewalks would be installed on the right side. And then this is on East Michelle Court, sidewalks illustrated in the blue line on this one. And then this is on South Stone Ridge Road. And when we spoke with the highway department, some of the issues that come up typically when you if you delay sidewalks until every lot is constructed, is now you have to possibly relocate utilities. You have to reconstruct driveways to make sure that the sidewalks meet ADA. You, in this case, have ditching. They got a detention waiver, so they actually rely on ditching in this area and existing vegetation to carry their stormwater. So you would have to redo the grading and drainage, which is why it's so expensive. And then this is the area facing south on South Stone Ridge. Again, the blue line representing where sidewalks would go. And then street trees would be every 40 feet on all lots. And then East Tierney the rest of the way. And then this was a stub that was approved on South Ann. Actually, this lot in the right side of the photo and the lot next to it, I believe, are currently under construction as of now. And then there's a view north on South Ann, location of sidewalks again in blue. And then here's their amended primary plat, just going through several pages essentially. The only thing that's changing is the removal of showing any street trees and any sidewalks. So because the requirements or the imagery of sidewalks and street trees are only on the preliminary plat or the primary plat, this would not technically need to be recorded after if this is decided upon tonight. The primary plat would be either approved or denied, and we would be able to move forward. They wouldn't have to record this or a secondary final plat. And then the applicant did submit a consent letter where they had a listing. It says, sign the petition. The petitioners are current homeowners of Bell Vista Phase 3 subdivision. We, the undersigned, are in opposition of the remaining improvements as outlined in the subdivision improvement agreement, SIA-22-28, sidewalks and addition of more street trees. So we did accept this as their letter from most neighbors. And then the reason I have page 3 again is because they had a copy of it and one person signed one version. They didn't sign the other version. But between last meeting and this meeting, we did end up sending a special letters to all the owners that we had GIS records for, which is what the rules of procedure say, to say you are hereby noticed that the developer is going through this process, because there were some people that did not sign that document. And here's a little bit more information. So there's 50 lots in Bell Vista. Upon counting all signatures and comparing that with the GIS, and also either receiving phone calls and talking to the person or documented voicemails, there are 3 missing in instances where lots are completely vacant and where the lots are completely vacant and yet to be built. Many owners own double lots, and in those instances, at least one signature was obtained. There was one instance where a renter signed and not the owner. There were 2 instances where the person that signed for the address had the same last name as the owner, but different first name, indicating maybe a possible nickname, or another family member signed not on the deed. There's 1 instance where the owners of one developed lot refused to sign the petition. And in some instances where it counted 14, only 1 person on the deed signed the petition and or left a voicemail or called us. And they were not all, it doesn't include all owners on the deed. So we did receive some support. We received 3 calls and 5 voicemails in support for the street tree and sidewalk waiver. 1 call and 2 voicemails were from residents of Section 1. 1 voicemail was from owners of Section 2, and 2 calls and 2 voicemails were from residents of Section 3. We also received a few emails from people, and this is in the packet. Originally, some people were confused and stated street lights. I reached out to every one of them and made sure they understood it was street trees and no street lights. And again, these should be in the packet. And then we received 1 letter of remonstrance from a person that wishes to remain anonymous. And that brings me to the staff recommendation. So staff recommends approval of the primary plat amendment for the street tree waiver, citing that there are several mature trees and there are some street trees that exist already in the area. And we're withholding the recommendation for the sidewalk requirement, citing that though there may be proven practical difficulties in implementing the sidewalk requirement today, those same practical difficulties could have been avoided if they were installed closer to the time of recording and platting. And originally, when this subdivision was approved, it had several conditions of approval. We went through those with the stormwater program manager, and we would like to carry forward the ones that are currently on the screen. just to make sure that it's clear with the transition to the CDO for some of those undeveloped lots. So for instance, number 5 states that building plans for all houses constructed on lots with sinkhole conservancy areas formerly 25 feet must demonstrate that the house footprints are not located within the sinkhole conservancy areas, which we would like to change to karst conservancy areas of 50 feet, which matches the county development ordinance change. And then since there are a few undeveloped lots, we feel that that would be helpful and important. So if there are any other questions on any of these or on these prior conditions which we're carrying forward, I'd be happy to take those.
Yeah, Commissioner Thomas?
We've talked about this petition a lot, as you know. And you know, I had hoped that we'd be able to find some really novel way to utilize this funding for folks who want to buy street trees or trees for their lots, to go ahead and do that. But it seems like there's no way to do that legally because it's outside right?
So if we were to say keep the 50,000, as I showed in the earlier slide, the street trees that were on the plat would equal an amount of about 81,000. So in the, I think the idea that was expressed was if people would like to put in the street trees, they could apply. But for our purposes to enforce with the developer which street trees go in and which do not, we have to plat those.
Yeah.
So the timing would be off of if people would like to have
Never
those
mind.
trees and put those in.
Got it. Thank you. Well, it was worth talking through.
That's a nice idea.
So, two questions. The first is, if we were to go ahead and revise this and do a sidewalk waiver and a street tree waiver, that money then goes back to the developer. Is that correct?
Correct.
Okay. The other question I had relating to this is that we saw something a month or two ago where there is a covenant on the properties and it relates to having sidewalks. If this primary plat, if it's amended by this board and it's not recorded, then what happens to all of those covenants on those deeds? Or if this is recorded, does that then impact those? Just curious.
Yeah, my understanding is the covenants and restrictions could be amended by a majority of the homeowners. I know there's not an actual HOA, but I didn't have any, I don't know if you wanted to add anything.
And I think by their terms that there's periods where they are automatically renewed or they expire.
Okay. So it has nothing to do with recording this primary plat if those waivers are then approved by this board. Thank you. It's late.
That is correct.
Okay, thank you.
Do any other members of the Plan Commission have questions for staff? Okay. Yeah, Mr. Ferris?
I'm exhausted on this topic. I guess the only real question I have, and I think you answered it, but please provide me an explanation. If we take and approve the sidewalk and the tree waiver, the 50K is going to go back to the developer and nothing will be done with that money. There's nothing we can take and do to spend that money on something or anything else, as you had indicated.
That's correct, because the letter of credit that was at the time was only for sidewalks, street trees, stop bars no longer required, and stop signs already installed. We're limited to that list, so I know there were some people that's called and stated support for, hey, if we could use that money to repave the driveway, the streets, I would love that. And unfortunately, because we accepted that into the inventory in 2008, we can't go back on that and say now the roads are insufficient and we need that money for that purpose.
Follow-up, do we have any examples or any type of a petition in the past where we have returned monies back to the developer because it couldn't be spent the way it was intended?
We have returned some funds back to developers, but typically it's because we are able to complete the project under the amount that they have. I don't have any examples personally where we've returned the full amount because it's because of this situation where we come back and issue waivers. Dave may have more historical information than I do on that.
No, I think in the past that we had the flexibility to use that on other improvements, but I think they tightened the law up a few years ago, and we can only use it on the improvements that the money was deposited for.
Thank you.
Yeah. Mr. Bush.
I have a question regarding condition number 5, and I'll read it just so maybe it makes more sense to me. In order to receive improvement location permit approval, building plans for all houses constructed on lots with sinkhole conservancy areas, formerly 25-foot, must demonstrate that the house footprints are not located within the sinkhole conservancy area, which is now being called the karst conservancy area, which is 50-foot. What happens if a house footprint is outside of the former 25-foot sinkhole conservancy area, but is now within the 50-foot newly defined karst conservancy area?
Because this is now a condition of approval, is that what you're saying? So we would, I believe, just take them through the variance process to go to the Board of Zoning Appeals to state that they're subject to the karst conservancy area. And if the Board of Zoning Appeals can issue a variance to allow them between the 25 and 50 feet for their footprint, say they're limited in other area, then they could move forward despite this condition.
So there is that avenue of relief for them.
That's correct.
Okay, thank you.
But if the house is already built, if I might follow up, if the house is already constructed and it's 30 feet away from the sinkhole, there's obviously nothing that happens.
Right, until they request an addition or some sort of modification.
Any additional questions? Yeah, Mr. Ferris.
And this is exhausting. So I'm inclined to approve both waivers. And I'm aware of what the staff has said with respect to no recommendation. And I note that the follow conditions that should be carried forward. And if I add these things up, there's 1, 2, 3, 4, 5, 6, 7 conditions. Have you all discussed those conditions with the developer, the petitioner, and is there any issue with satisfying those conditions?
We have not specifically, we might have, it's been so long. I don't believe we've gone through those conditions again with them. They're currently in effect on this subdivision. So I think with this process, we're kind of cleaning them up, acknowledging that some of them have already been addressed. So I don't believe that they have had any opposition to this because it's already what's on the plat.
Thank you.
Any additional questions for staff before we turn to the petitioner? Okay, seeing none, we can turn to the petitioner's representative. If you could sign in, state your name, you'll have 15 minutes.
Good evening. My name is Larry Allen, representing the petitioner this evening. I only brought 50 slides with me for a half an hour presentation. I'm just kidding. I don't want to, I think you all have had an extensive conversation about this, and we really appreciate it in terms of, from the developer perspective, just to be really clear in terms of the conditions that are on the plat, since that was the last question that was asked. The conditions on the plat largely, as I've interpreted them, they're largely just updates to reflect the realities on the ground. So saying that if there's any new development, any new petitions, they do actually have to follow the law as it exists, which they would have to do anyways, regardless of what was on the plat. So in terms of what the sinkhole thing is, who you're coordinating with, whether it's called an environmental director, et cetera, et cetera, et cetera. So we have read those, we understand those, and I think the owners could understand those, and the planning staff would go through that with them. In terms of everything else, I think it's been well covered. I don't want to rehash anything. We do have a technical expert with us here tonight. Drew Schrand from Bynum Faneuil is here, so if you do have any technical questions, he can help answer it. Otherwise, I'm very happy to answer any of your other questions.
Thank you, Mr. Allen. Do any members of the Plan Commission have questions for Mr. Allen or Mr. Schrand? Okay, seeing none, we can turn now to public comment. So if there's anyone here in the room who is in favor of street trees and sidewalks being installed, please come to the podium. If there's anyone online who is in favor of street trees and sidewalks being installed, please raise your virtual hand.
That mean that they're in support of the petition, since the support of the petition would be to not have sidewalks and street trees?
Yeah, I was trying to clarify that. I was calling for anybody who would like to have sidewalks installed
So
first
opposition.
in opposition of the petition.
An opposition.
I think we could,
Just comments.
I think we could just do any
Just
comments, yeah. It seems like everybody
Anything.
has largely the same opinion.
I think it's too hard to categorize, so.
Yeah, if you could sign in, state your name, you'll have 3 minutes.
And just be clear about what you would like or don't like about the potentials here.
Okay, you're welcome to go ahead. You'll have 3 minutes, sir.
I'm Ariel Axelrod, and I'm a resident in Bell Vista, Section 3. I'm here today to ask that the Plan Commission deny the applicant's amended plat petition. I do this because, one, the applicant lacks standing before this body to amend the subject plat, which is the reason that we kind of had that whole thing about residents maybe doing a petition. Applicant's standing is satisfied by one of the following. The applicant must own the subject property. He does not. The applicant can be an agent for all property owners. The applicant is not. The applicant must be the legal representative of all the property owners. The applicant is not. Setting aside standing for a moment, the objection petition the planning department accepted as consent was circulated by some Bell Vista 3 property owners because they were misled into believing they would be held financially responsible for more than $620,000, that was the number at the time, in public improvements the developer agreed to 19 years ago. The pitch was, and I know because I'm one of those that was approached with this, if you don't sign this, we will have to pay for sidewalks. The fear-mongering stirred up a frenzy as some neighbors feared being held financially liable for the applicant's agreements that had been renewed each year for 17 years. A review of the objection petition shows 35 addresses in a 50-lot subdivision. Even if the submitted signatures are counted as valid, aligning signatures to addresses on the objection petition yields, at best, 32% of all owners having objected to sidewalks and street trees. In other words, 68% of the property owners or properties did not. I would be remiss if I did not point out the developer has misrepresented 100% consent to the planning department when the commission petition was submitted. It states, support for this request is signed by 100% of the current property owners of Bell Vista 3. On October 23rd, Monroe County Planning Director notified the applicant's counsel that they did not have 100% consent when she emailed. Quote, when we received your petition letter and consent letter, we were originally under the impression 100% of lot owners had signed off. As a result, we did not require property owners notice letters. We will need to continue the meeting to our November meeting and provide you with new letters to send out as required. Despite having been notified of the material misrepresentation in the applicant's petition, the applicant has not corrected or amended the application, thereby continuing to misrepresent that 100% of the current property owners signed the objection petition. Finally, it is the developer who is the one that caused the conditions he now seeks to use to avoid meeting his legal obligation to install sidewalks and street trees. Therefore, I ask that you deny the application.
Thank you, Mr. Axelrod. Is there anyone else here in the room who wishes to speak either in favor or against this petition? Please come to the podium. If you could sign in, state your name, you'll have 3 minutes.
Hi, William McGannon. I live on Bella Vista Phase 3 on Tierney Street. I've been there a little over 17 years now. So first, thank you guys for all the jobs you guys do. Monroe County is a beautiful area, so really do appreciate you guys taking the time to hear us out and everything. Yeah, for the last 17 years, I've lived there, and sidewalks haven't been an issue. Phase 1 and Phase 2 don't have them. In Phase 3, it doesn't really make sense. It wouldn't go anywhere. It wouldn't connect with the rest of the Bella Vista. So it really is kind of discongruent with the rest of the development. I think we mentioned that there's utilities there, so we definitely don't want to start digging around and putting sidewalks in because it will drive the cost up tremendously. It's a neighborhood, and when people go there, they drive in. It's not a throughway, you know, so people aren't just speeding through there. So traffic's pretty light, pretty calm. So when people do walk on the street, they're not like fighting traffic or anything like that. So it's a pretty safe environment. So I don't think sidewalks are really needed. There's a lot of different grading issues going on too. So again, a lot of construction and things would be needed. So pretty against the sidewalks. Trees, lots of trees in the area. Get a lot of shade already. Maybe one little section could use a tree, but okay, I'll plant a tree for you if you want me to. But no, we don't need trees or sidewalks. So I'm in agreement that this gets waived as a condition, and the money gets returned. Probably not my business, but as a resident of Bella Vista Phase 3, I don't feel that we need the sidewalks or the trees. Thank you.
Thank you, sir. If there's anyone else here in the room who wishes to speak, you're welcome to come to the podium. If there's anyone online who wishes to speak either for or against this petition, please raise your virtual hand. I'm not seeing anyone's hands raised. Do you see any, Jackie?
Don't see anyone.
Okay, thank you. So we can close the public hearing portion of this. Thanks to everybody who came out and spoke, and now come back to the Plan Commission for discussion. So let's start on my left. Mr. Bush, do you have any comments to share?
Yeah. What a pickle. I'm dismayed that the Plan Commission is in this box right now, that we're forced to either accept returning the monies back to the petitioner, or forced to construct something that the public doesn't seem that is desirable and necessary. So I'm not going to be supporting any motion that puts any of the cost on the homeowners, because they shouldn't have to bear that cost. That was a mistake that was made years ago between the county and the developer, and no one has held their feet to the fire to this point. So public shouldn't be forced to pick up the slack or pay any of that. So that's what I've got to say. Thank you.
Okay, thank you, Mr. Bush. Mr. Van Deventer, do you have any comments you'd like to share?
No, I'm fine.
Okay, Mr. Fields?
Yes, I agree. It's a pickle, and it's an ugly situation, but at some level, I really appreciate Mr. Axelrod's comments. I think that the developer has put everyone into a bad position, all of the people, but apparently the people knew about the position. He's put this body into a really bad position because as this body, if we say, okay, yeah, we're going to waive all this stuff, we're into a situation where we have created a precedent that is, I think, just not workable. This precedent basically says, and from everything I've heard, is we don't want these because we don't want these. No one has come back with anything that seems to have merit to me that says they can't do it. It's just that the can got kicked and the can got kicked and everything else. And we put ourselves into a situation as a plan commission that we are over a barrel. And I don't see a way to do this other than to say, no, street trees, I'm fine. We've got enough trees that, we can work around street trees. I'm fine with that. But this sidewalk thing, I see nothing that says that this is something that we should waive and for the stated purpose of we don't like it.
Thank you, Mr. Fields. Commissioner Thomas.
It is difficult. I've started looking at this as an error that was made in previous administration of the planning department, rather than looking at it as something the developer did or didn't do, or that the residents did or didn't do. And that's helped me think through this a little bit differently, because yes, we are, painted into the proverbial corner, and we have to do something just to solve this because it does need resolution. And I agree with everything everyone's said so far. It makes perfect, I don't want people to be responsible for paying for this, but at the same time, my gosh, what a huge expense. And that's who would be responsible for it. I actually have a question based on the comment we received a moment ago, and it's for Mr. Schilling. And I wonder, Mr. Schilling, if you could speak to the issue of whether or not this petitioner has standing to revise the preliminary plat.
He is the developer that has the agreement with the county, and that's what we would be working to enforce.
Got it. Thank you.
Thank you, Commissioner Thomas. Mr. Ferris, do you have comments? Okay, Councilmember Henry.
Thank you, and thank you, Commissioner Thomas, for raising that. It was exactly my question too, because if not that, who are we taking the development into inventory from, right? I mean, we still have that very long lingering space that we're in. So and trying to do law on the fly with a presentation like this. My only question was, is this the first time this document has been presented, right? We didn't have this in advance.
That's correct.
Okay, so this is the first we've seen it 15 minutes ago. Yeah, so thank you for asking the question about standing. I think that was important because I just don't know who we'd be receiving the development from once the requirements were eventually met. I agree with the comments of my colleagues here. This is a difficult situation. I think I did raise this at my next comment at an admin meeting or a previous meeting. I think I did anyway, that, and this is a question for staff, that do we anticipate that we may bump into a situation like this again? If we are setting a precedent, which is a concern, it's a concern that we do have other potential developments in the county that could end up this way. It was just a concern where we might see, I guess, copycatting, if you will, down the right road. Do we feel like is there anxiety about that at the moment from staff?
Probably not anxiety, but we do have some subdivisions that we have accepted into the inventory without fully seeing that bond expenditure or those improvements fully made. So we have been taking a look at that with our highway department and trying to come up with a plan for how to go after those next developments to use the money as quickly as possible, because as we know, inflation is making it harder and harder for that money to go as far as it used to. So I don't know that we'll necessarily be seeing a waiver as much as we'll just have to deal with this situation and work with the developer. And if the developer doesn't like posting more money or completing those improvements, we have options under the CDO, and they could come back before you as one of those.
And I can't worry about too much of the future, but it just reminds me of like building models as a kid. You get almost to the end and it's the one piece that's missing. And now I'm stuck with a not quite finished thing. And that's really what we're talking about when we get, 98% there, and then we have, 98% developments all over the county that never quite got to the finish line. I would just hate that we are setting up a whole mechanism to do that. But I appreciate all the comment here, but obviously this is a pickle, I think is the term of art tonight. So thanks on that.
Just to add very quickly, I think this is a situation of the past that is not going to be replicated in the future, because we have new methods for tracking bonds, but also a much greater awareness among planning staff and the highway department about what these requirements are. And so I think what we're doing is hopefully fixing the last few bits so we can proceed smoothly. That's my take on it. Thank you.
And I'll share my comments real briefly. I agree with the majority of what's been said tonight. I think that neighborhoods benefit from sidewalks, and I think they build a sense of community in a neighborhood. And I think it's disappointing that the developer didn't adhere to the commitments they made to that neighborhood years ago. But I think ultimately the county made a mistake by accepting this into the inventory, and I wouldn't feel comfortable putting that burden back on the homeowners at this point. So I'm in favor of granting the waivers. So unless there's any additional comments from members of the Plan Commission, I will call for a motion. Mr. Ferris.
I just want to add that we're cleaning up broken glass here. And that's the best way I can summarize this issue. So let me explain this, and hopefully you all agree with what I'm going to say, because it gets a little complicated. With respect to Sierra Papa 25-2, which is a primary plat amendment with 2 waivers and also a waiver of final hearing, I believe that we need to take and address the street waiver and the sidewalk waiver separately with a vote. But in all cases, we need to make sure that the conditions that were stated on the board there, as you see them, they will be carried forward as original conditions for approval. And so saying that the motion I'm going to put on the table first is to approve the street tree waiver.
Second.
Okay. It's been moved and seconded to approve SPP-25-2. We're breaking this into 2. The first motion is to approve the street tree waiver and the waiver of final hearing. And this also takes into account the following conditions of approval, which I'll read into the record now and will not read again for the sidewalk vote. So the following conditions shall be carried forward from the original conditions of approval. Number 5, in order to receive an improvement location permit approval, building plans for all houses constructed on lots with sinkhole conservancy areas, which were formerly 25 feet, must demonstrate that the house footprints are not located within the karst conservancy areas of 50 feet. Number 6, permanent markers describing all of the sinkhole conservancy areas shall be installed at a minimum of 50-foot intervals. Number 9, where possible, runoff shall sheet flow from the road. Number 10, the shallow depressional area on lot 49 shall be maintained to drain. Number 12, a detail is needed of the typical roadside ditch sections showing the side slopes and depth. The roadside ditches shall be over excavated 6 inches and backfilled with topsoil, except for the 500 feet of ditch, which shall be over excavated 18 inches and backfilled with topsoil. This is still a requirement for new lots moving forward. Number 13, roadside ditches and road embankment slopes of 3 to 1 or steeper shall be stabilized with mulch held in place with netting with erosion control blanket or other approved method. And number 14, the types of vegetation in the roadside ditches shall be subject to approval by the stormwater program manager. A vote yes is a vote to approve the street tree waiver with the conditions stated and the waiver of final hearing. Julie Thomas.
Yes.
Joe Van Deventer.
Yes.
David Bush.
Yes.
Scott Ferris.
Yes.
Rudy Fields.
Yes.
David Henry.
Yes.
Jeff Morris.
Yes.
That motion passes 7-0.
Mr. Ferris, are you willing to make a motion on the second half of
will.
this?
Again, with respect to Sierra Papa 25-2, the second motion here is to approve the sidewalk waiver.
Second.
It's been moved and seconded for the other part of SPP-25-2. This motion is just to approve the remaining sidewalk waiver. A vote yes is a vote to approve the sidewalk waiver portion of this petition. David Bush.
Yes.
Scott Ferris.
Yes.
Rudy Fields.
No.
David Henry. Jeff
Yes.
Morris.
Yes.
Julie Thomas.
Yes.
Joe Van Deventer.
Yes.
Okay, that motion carries 6-1.
Thank you to all the members of the neighborhood who have organized your thoughts and come out to speak on this numerous times. Thank you. So that takes us to the end of our agenda tonight. Is there anyone here who wishes to speak during the public comment portion of the meeting for any items not on the agenda? If so, please come to the podium or raise your virtual hand if you're online. Seeing no one, we can turn now to reports. Jackie, are there any planning reports for us tonight?
I do have some exciting news to share. We were approved for our hiring of our planner 2, so we were able to get through the council and they lifted the hiring freeze for us. So that is great news. We've already started posting that and we are going to try and move as quickly as possible. And I think we will get some very qualified and good candidates. So we're excited.
Thank you, Jackie, for your work in getting that approved with the council.
And
Mr. Schilling, any legal reports?
No, no
Okay.
reports.
Okay, with that, I hope everybody has a great Thanksgiving holiday next week. Do we have a motion for adjournment?
Motion to adjourn.
Second.
Thank you all.